once again, and thank you so very much for coming. Without wasting any time, I would like to request you to start with the today's session.
Thank you. Good afternoon to the faculty members of the Law Code, to all viewers. And I wish that in this sphere of time, you all are having safe, happy and healthy life. And we all shall also, by adhering the norms of the safety, shall keep on fighting against this global pandemic. I want to extend my gratitude that towards the Law Code, for which they have initiated their process for upcoming lawyers, law students, and they are doing their best and good by providing them the legal awareness through this institution. I would also like to thank the members of the Board of Law Code for inviting me as a which is topic of this webinar. Now, coming back to our topic, the Right to Information Act, progressive and regressive issues of the Act, which are in relation to have been discussed in the judgment of Honorable Delhi High Court, CPIO, Supreme Court versus Subhash Agarwal. This judgment on perusal and evaluation clearly goes to show and brings the point which clearly reflects that what is the aim and object of this Right to Information Act. As we commonly know, in short, this act is called RTI Act. This act contains 28 sections, and these 28 sections have been martially compiled in a thin booklet While proceeding further, I want to add that unimpeachably being true, the country which we belongs, being a democratic based regime where people are termed absolutely, indubitably highest paramount sovereign in chief as the strong and solid pillar for the democracy. As it has been rightly said by Abraham Lincoln, that the government is always of the people, by the people, and for the people. So, in democracy, as like our own country, the people are termed to be master, and all the civil servants, all the public servants are their servant as servant of the master. Therefore, with this ratio of the position, all the servants are supposed to disclose to their master as to in which manner they are acting while discharging their functions, discharging their duties, and also in what details they are acting while discharging their duties. And even the master is required to be made aware through the informations, including the decision-making process, meaning thereby RTI act as a watchdog for the masters. Now proceeding further, this RTI act apparently if read or seen or evaluated, then it clearly goes to show that it is a revolutionary act which aims and do possess the object that the sole project is to promote the transparency by maintaining and adhering persecuteness in the government institutions. This act came into existence in the year 2000, RTI Act 2005, and how it came after sustained efforts of anti-corruption activists. If I add further, this act, being a revolutionary act, is innovative and originative to the people because it opens government institutions. It opens all ancillary institutions attached with the government. The institutions which are being given financial aid by the government and the institutions which are governed by the Constitution of India are available for scrutiny for the people, and at any point of time each citizen of India can invoke the provisions of this act by seeking the information in regard to their discharging of duties and the functionaries as being opted for governance of the country. Equipped with the knowledge about RTI, a common man can demand any government agency to furnish the information. This organization with whom the information has been sought by the information seeker, it has been envisaged in the act that within 30 days of the receipt of the application from the information seeker, the information is bound to be delivered to him. Failing which, and for inactions of the government authorities, a penal provision has also been provided in this act, which slaps the fine on the person, on the officer who is not providing the information and who is supposed to provide the information to the information seeker. Now, how this RTI Act further by adding, in continuation of my views, the government authorities and all its institutions have articulately enunciate and express the response to the information seekers, to the citizen, to the public of India who have sought information of the functioning or on any project of the government as and when demanded. Now, in order to initiate and to know about this act, if further quick travel is required to have for the provisions of this Right to Information Act, there are sections in this act which provide and gives knowledge to the citizens as to in which manner and how it is to be invoked, what are the powers which are required to be invoked by the citizens for getting the information, the importance of Right to Information Act. There are 5 points on the study which I had pointed out, these 5 points I want to share with you. The first point, which do carry an importance, is the law empowers the people to ask information about central, state government, including non-governmental organizations, which are substantially funded by the government. The second point, the law gives citizens of India the tools to fight against the corruption. Number 3, the RTI gives people the right to hold the government and organizations substantially funded by the government accountability. Fourth, the Right to Information Act gives citizens the right to ask for the information and decide based on the information received whether their constitutional rights have been met or not. Fifth point, the law arms individual with the information so that they can advocate for themselves. So, while proceeding further, it is to be seen what does the RTI Act do? What are the basic which are to be kept in mind before invoking the provisions of RTI Act? Under RTI Act 2005, the public authorities are required to make disclosure on various aspects for their structure, for their functioning, and in which manner the duties are being discharged by them by making and giving services to the nation. This includes disclosure on their organization, function, and structure. Second, the power and duties of its officers and employees. Number 3, financial information. The intent of such suo motu disclosure is that public should need minimum resources through the Act to obtain such information. These may include the informations in the front of documents, in the shape of files, in the shape of notings, the electronic records under the control of the public authority. The intent and what was the need arisen for framing of this act was to promote complete transparency and accountability in the working of public authorities while discharging their duties. So, proceeding further, in section 2 of the Act, various definitions have been provided which spells out as to which are the authorities, where the citizen can file his application, how those applications are to be dealt with, which is the appellate authority, what informations can be said to be protected or non-disclosure informations. So like this, section 2 is important, which envisages the definitions. Now, a quick review of this would go to show that section 2A defines appropriate authority, where the authorities have been defined, which are the appropriate authorities. Section 2B, in commonly we say CIC, Central Information Commission. So this is the highest authority in the Act, where the information when not disclosed, we can say the second appellate authority is the CIC. Section 2C says Central Public Information Officers. It has been defined who can be appointed. Section 2D, which is the first authority of each government department, where the government have appointed in relation to their functioning and discharging of duties, that as and when information is sought by any information seeker. So this is the first information authority, which we say this Chief Information Commissioner. And thereafter in section 2E, competent authority has been defined. Section 2F, information has been defined, which I have earlier said what is information. it says that information means in any form, including record, document, memos, emails, opinion, advice, press release, circulars, orders, logbook, contract, report, papers, sample papers, models, data material held in electronic form, and information relating to the private bodies which can be assessed by a public authority under the law for the time being in force. Section 2H defines public authority. Then 2I defines the record. 2J defines the right to information. State Information Commission 2K. State Chief Information Commissioner 2L. Public Information Officer 2M. And third party has been defined in section 2N. Now, these definitions have been met in judicial verdicts where the honorable respective high courts, where the honorable Supreme Court of India have come across while dealing with definitions, and more elaboration has been provided in the situation which reached to the court where these definitions were considered, and in regard to these definitions, the legal observations have been given. Now, section 2E, as I have stated, competent authority. This issue came for discussion before the Honorable High Court of Delhi, and which is our subject matter also, CPIO versus Subhash Agarwal, as this matter was first considered by the single judge of the Honorable Delhi High Court. Then it went before the division bench, as the CPIO Supreme Court has also assailed that judgment. So in LPA number 501 of 2009, this definition was elaborately discussed, which I will later on discuss while coming on the case law, which is required to be discussed today. Now, section 2F, as I've stated, which contains the definition of information. This also came for a discussion in judicial verdict. In AIR, what information in fact sees, what it reflects. So this ratio of information, which later on included in RTI Act, this information was considered by the Honorable Supreme Court of India in Reserve Bank of India versus V. Jayantilal and Mistry and others. So information, what it can be, it has been detailed in this head judgment. Further, these definitions in context to the draft judgment and the personal notes of judges not to be information. So sometimes the information seeker, he asks that what are the notes prepared? What is the draft for this? So in this context, our own Delhi High Court, firstly at the single judge and then the division bench, in the case of CPIO Supreme Court versus Subhash Agarwal, it has been held that these are the essentials for maintaining the information and what documents can be part of information and what cannot be the part of information. Proceeding further, in section 2F, as I have stated, that information regarding personal assets, which is the main subject of our today's issue, of the judges of High Court, whether it can be sought or not, again, this aspect in detail with full elaboration has been cogitated by Honorable Delhi High Court. So while discussing that judgment, it will come. Public authority, this issue has also been discussed, and again, it came before the Honorable Supreme Court of India in case of Public Bihar Service Commission versus Syed Hussain, Abbas Rizvi and another, 2012, 13 SCC, page number 6. Proceeding further, section 2J, the information which relates to the personal information, the confidentiality required to be maintained of the medical records of a patient, including a convict, considering the regulation framed by the Medical Council of India, cannot override the provisions of Right to Information Act. And in this context, this definition was evaluated in a case decided by Bombay High Court in writ petition number 1750 of 2007. Section 2J, the significance of this definition has been elaborated again by the Honorable High Court in case of Registrar of Companies versus Dharmender Kumar Garg and another. This is writ petition number 11271 of 2009, wherein it was held that under the control of the public authority in relation to the information means the information which is held by public authority under the control to the exclusion of others. So proceeding further, in relation to the other provisions of the Act, it is classified that who included in the ambit of public authorities, it is mentioned in the Act. Who is the right to information enforced under the Act? What information according to the RTI Act? What does this right to information means? What are the obligations of the public authorities? Who are the public information officers? In short, we say PIOs. How to file an RTI? This process has also been provided in writing or through electronic mode. It can be done. Which government organizations are required to give RTI information under the Act? Which government departments are exempted? Now, in this Act, there are 20 odd organizations which have been exempted. Those have been mentioned. So, in section 22, the overriding effect is also mentioned. How powerful the RTI Act and how RTI any difference from the anti-corruption laws. So, what is the fee required for obtaining these informations? Which are the appellate authorities? What are the penal provisions? So all these have been mentioned and envisaged in this Act. Even this Act was tabled for to be amended, and this bill in 2019 was brought, where 3 provisions of this Act were sought to be amended, where in RTI Act 2005, the Chief Commissioner, the Chief Information Commissioner and Information Commissioner at the center level or the state level, as it in 2005 it was stated to be having a term in his office for 5 years. But what now it is to be proposed, and is proposed, the bill removes this provision and state that central government will notify the term of office of CIC and IC. Second amendment in relation to the quantum of salary, and third, reduction in salary. So these 3 provisions which are sought to be amended is still pending, although in Parliament a discussion has taken place and the opponents have given their reasons why this amendment shall not be there, and they have added that this amendment infringed the right of a common person. It has also been proposed that this amendment which they are seeking, it will be termed as an RTI elimination bill, but it concluded that it has been passed at the first floor, and rest it is to be seen when it will be enacted. Now, proceeding further, our today's subject in relation to the judgment which is having a title CPIO, Supreme Court of India versus Subhash Agarwal and another. So, what are the facts of this case? as it has been detailed in full elaboration, how this initiation came, what were the provisions considered, and what are the legal observations of the Honorable High Court. Now, this is a case where the respondent Subhash Agarwal, who initially, being an applicant, applied before the CPIO Supreme Court that he is in need of information and had made an application in writing before the Supreme Court, wherein he has sought the information. The first question of his information which he has brought before the said concerned authority was that I will be obliged if your honor very kindly arrange to send me a copy of the said resolution passed by the judges of Honorable Supreme Court on 7th May 2007. This was the first query. The second question which the applicant has mentioned is that I will be obliged if your honor kindly provide me information on any such declaration of assets, etc., ever filed by honorable judges of the Supreme Court. Kindly also arrange information if High Court judges are submitting declaration about their assets, etc., to the respective chief justices in the state. So, taking these two questions, these were to be replied by evaluating the provisions of RTI Act. And at initial stage, the reply was given to the applicant that the resolution which he is asking for, that resolution can be provided him subject to certain required payments as envisaged in the Act. Regarding the second query, the answer which has been given by the CPIO Supreme Court, that was not a complete answer, which felt that it should be challenged before the appellate authority. And the appellate authority, first appellate authority, was approached by the applicant. And the first appellate authority, after seeing the order of this CPIO, had remitted the matter back, that in regard to the information as sought by the judges of respective high courts by providing their financial asset report to the concerned chief justices, this application could have been dealt with by invoking the provisions of section 6(3) of the RTI Act, and it could have been referred to the respective branches from where that information can be sought. And this matter was remitted back for fresh consideration. However, at the second round of litigation of this information, again the CPIO had only satisfied the applicant regarding his first information, the resolution was provided, but the application of the information seeker was negativated in regards to the second query as raised by him. Having no other option, the said applicant Subhash Agarwal had approached Chief Information Commissioner, CIC, the authority as available in law. And the CIC, after evaluating the said order and had decided in favor of the applicant Subhash Agarwal by observing that the information as sought by him is required to be provided to the applicant, and it was observed by the CIC that thereby directing the CPIO Supreme Court, it was directed that the information be provided to the appellant in his RTI application as to whether such declaration of assets, etc., has been filed by the honorable judges of the Supreme Court or not. And a further direction was given that within 10 days, this information from the date of receipt of that decision is to be given. Now, during the evaluation of the submissions, the case law, the CIC has come across the issues regarding the definition of public authority, wherein after considering at length, after considering the various case laws, it was held that it is a public authority. Honorable Supreme Court is a public authority and this information is to be provided. It was further held that by observing, it is clear that neither the CPIO nor the First Appellate Authority has claimed that information asked for by the appellant is exempted either under the clause 81E of the Act, being received in a fiduciary relationship, or that the information is personal information attracting the provisions of section 81J. So when this order came to be passed, CPIO Supreme Court has assailed this finding of the CIC before the Honorable Delhi High Court, and the matter came in a writ petition before the single judge of the court. During the course of the argument, the Registrar Supreme Court was also added as a party suo motu, and Delhi High Court Bar Association was also added as one of the party. The arguments were heard at length. CPIO Supreme Court was being the petitioner, was advocated and counseled by their counsel, where during the course of their arguments, each word and each section of the act was narrated, evaluated to seek the favor, thereby seeking relief in their favor for setting aside the CIC order. In so many words, during the course of their arguments, it was admitted, and it was bound to be their admission on their part regarding that there is no doubt, and it is true, that in democratic framework, free flow of information to the citizens is necessary for proper functioning, particularly in the matters which form the part of the public and public record. The argument qua right to privacy was raised. The argument qua fiduciary relationship was raised. The argument qua protected personal information was raised. And on the other hand, the respondent, who was Subhash Agarwal in that proceeding, they had also argued by bringing various judicial verdicts before the single judge. How is the functioning? What are the powers? How those powers are to be invoked? What are the rights of the citizens? And once the citizen has asked, under what provisions of law he can be stopped from seeking the information? What are the public authorities? Whether the Supreme Court is a public authority or not? Whether the office of the Supreme Court of India, Chief Justice Office, can be segregated from the office of the Registry of the Honorable Supreme Court? Whether the informations which were kept on the basis of the resolution can be said to be confidential and cannot be made public? So these various issues were raised by the respondent also, seeking the prayer that the writ petition being false, having distorted facts, is the order to be dismissed. Various provisions of the Constitution of India were also discussed, and ultimately the honorable judge came to the conclusion that before deciding all these issues which have cropped up in the litigation in that writ petition, 6 points as a subject matter of the issues were framed by the learned single judge, and the narration of those issues is must to be disclosed so that the appreciation could be made what was the ratio of law in the said judgment. The first issue which was framed by the Honorable High Court was that whether the Chief Justice of India is a public authority. Second, whether the office of CPIO of Supreme Court of India is different from the office of CJI, and if so, whether the act covers the office of the CJI. Number 3, whether the assets declaration by Supreme Court judges pursuant to the resolution of May 1997 is information under the Right to Information Act 2005. Issue number 4, if such assets declaration are information, does the CJI hold them in a fiduciary capacity, and are they therefore exempt from the disclosure under the Act? Question number, the issue 5 which was raised, whether such information is exempt from disclosure by the reasons of section 8(1)(j) of the Act. And the 6th, whether the lack of clarity about the details of assets declaration and about their details, as well as the lack of security, renders the asset declaration and their disclosure unworkable. So these were the issues which Honorable Court found fit to be framed, which could be answered, and an effective adjudication could be done in context to the subject in issue. Now, point number 1 and 2, they both were considered jointly as the facts which were brought before the learned judge were in common regarding these two questions. And during the course of hearing, what is public authority was dealt in detail, coupled with various case laws, and ultimately, after discussing the issue, what the single judge came to the conclusion, it was observed what this court cannot ignore, regardless of varied roles of the CJI, is that they are directly relatable to his holding of the office of the CJI and heading the Supreme Court. His role as a Chief Justice of India is by reason of appointment to the High Court office of the head of the Supreme Court. The first petitioner did not assign the application either to the CJI or to any other office of the authority, office or authority. It is not also urged that such office has a separate establishment with its own public information officer under the Act. There is no provision other than Section 24. Exemption organization. The provisions exempt that through the second schedule of the said Act, the Intelligence Bureau, Research and Analysis Wing, Cabinet Secretariats, Directorate of Revenue Intelligence, and so on. These are the authorities which were pointed out to be having exemption under Section 24(2). So, Keeping this all in mind, it was held that there is no clue in these provisions that the Office of Chief Justice of India is exempt. The country, on the contrary, internal indications in the enactment point to even the President of India being covered by the Act Section 2H and 2E, subclause Roman 4, to conclude that the CJI does not hold any asset declaration information in the capacity of Chief Justice of India would also be incongruous, since 1997 resolution explicitly states that the information would be given to him. In these circumstances, the court concludes that CJI holds the information pertaining to asset declaration in the capacity as the Chief Justice. The office is thus held to be a public authority under the Act and is governed by the provisions of the Right to Information Act. So one thing has come clear, that the Honorable Supreme Court of India, in relation to providing of the informations, cannot be said to be supreme against the master of the democratic country, against the citizens of that country. So, in order to decide further issues as containing in remaining subject in issue, issue number 3 was also dealt with, wherein the information was evaluated ki what can be said to be an information, and if the question number 2 do possess the information, then how it is required to be cogitated in law. What are its evaluation? What depth these submissions do contain, that yes, it ultimately culminates in the form of an information. So during the course of the argument, various again case laws were dealt with in regarding to this question number 3. And ultimately, while discussing and having an apparent perusal of the facts and submissions, the Honorable Single Judge had concluded by observing that, in view of the above detailed discussion, it is held that second part of the respondent's application relating to the assets declaration by the Supreme Court judges is information within the meaning of expression of Section 2F of the Act. The point is answered accordingly. The information pertaining to the declaration given to the CJI and the contents of such declaration are information and subject to the provisions of RTI Information Act. Now, one thing it was made clear by the single judge, that the declaration which the CJI has sought from the respective other judges of the Honorable Supreme Court is an information which is available in the office of the CJI. But this information is required to be met, whether it is protected or not, in view of the other provisions of the Right to Information Act. So two things become clear. The office of CJI is a public authority, and the information that this office do possess, the record do possess, those are termed to be informations in view of the RTI Act. So while proceeding further, the Honorable Delhi High Court has considered, by observing that the petitioner's argument, the CPIO argument, which assumes that the asset declaration in terms of 1997 resolution, which I have earlier discussed, that resolution is also available in the judgment. And on its plain reading, it can be seen, which has been read by the Honorable Court and has been made part of the judgment. So on the basis of that, what further argument has been developed is that the asset declaration in terms of 1997 constitute information under the Act, yet it cannot be disclosed, or even particular about whether who made such declaration cannot be disclosed, as it would entail breach of fiduciary duty by the Chief Justice of India. Now, this was another limb of argument which was raised, that even if it is held, then even then this respondent is not entitled for any information. The petitioner relied upon section 8(1)(f) to submit that public authority is under no obligation to furnish information available to a person in the fiduciary relationship. And it was quoted during the course of argument, one line from that resolution. It reads that the declaration made by the judges or Chief Justice, as the case may be, shall be confidential. Now, the petitioner CPIO has taken shelter of these words, attempted to take a shelter of the provisions of section 8, and the matter was argued in length in order to see what are the fiduciary relationships, what is the fiduciary capacity of a person who is holding the office. So again, in depth, with complete elaboration, it was seen and legally examined, and all the case law were legally mirrored. Situations were judicially scrutinized minutely in order to see whether the argument raised by the petitioner's counsel do possess the merits, and the information which has been held regarding the record would be said to be confidential and would be retained in a fiduciary capacity or not. Section 88 of the Indian Trust Act also came across, which was evaluated, which says about the advantage gained by the fiduciary. It was dealt in depth. The following kind of relationship were broadly categorized to be as fiduciary: trustee beneficiary, section 88 of the Trust Act 1882, legal guardians ward act, section 20, lawyers and client, parents and child, doctor and patient, liquidator and company, board of directors and company, executors and administrators, legatee and heirs. So, in order to evaluate further, it was examined in detail, and it was observed by the single judge by holding that it may be seen that the fiduciary relationship is one whether a person places complete confidence in another in regard to a particular transaction of his general affairs or business. The relationship need not to be formally or legally ordinate or established, like in case of a written trust. So after evaluating all these things, when the matter was brought in light to the facts of the case, it was seen that so far as the argument of the petitioner in connection with the 1997 resolution of the Honorable Supreme Court judges, it has imposed a confidentiality obligation on the CJI to ensure non-disclosure of the assets declaration is concerned. The court is of the opinion that with the advent of the Act, the provisions of section 22 of the RTI Act, which overrides the other law. Now, this section 22 of the RTI Act was also considered, which have an overriding effect. Merely, and had stated that merely marking a document as confidential in the case does not undermine the overriding nature of section 22 of the RTI Act. So after evaluating the provisions of section 8, the provisions regarding the information and fiduciary relationship, the provisions of section 18J regarding providing information, or it could be said to be a information as a protected information or confidential information. Again, the third limb of argument was raised as to what is the right of privacy, right of information vis-a-vis a right of privacy, how it is to be dealt with, how it is to be covered, what are its evaluation, what shall be the essential features in governing these issues. So in order to appreciate the arguments from the both sides, number of case laws were again discussed on this aspect. And one of the case where the Constitution Bench of the Honorable Supreme Court, in case of OK Ghosh versus EX Joseph, was considered, which was claimed that the Honorable Supreme Court said that the individual does not forfeit his fundamental right by becoming a public servant. So this argument was also raised, so that right to privacy could be maintained, and the respondent could be declined for his query which was sought to be made by him. After having this evaluation, the Honorable Single Judge has held and observed that this information, on the basis of which it has been held that this is an information, it was observed that it is not a protected information, and it was observed that a private citizen privacy right is undoubtedly on the same nature and character as that of the public servant. Therefore, it would be wrong to assume that the substantive right of the two differs. It was further added that the nature of restriction on the right to privacy is therefore a different order in case of the different individuals. The degree of protection afforded is greater, and in the case of the public servant, and the degree of personal information is demonstrated in the particular fact of the case by way of objective material or evidence. So the court said that while keeping all these issues in mind, the court cannot be unmindful of the fact that several categories of public servant, including the central, including the state government servants, as well as the servants from the public sectors, government undertakings, and other offices of the statutory corporations are required by the service rules who have also to declare their assets in view of the provisions of those acts. So, in view of the provisions of these acts, what further concluded that the obligation to provide the impaired access to the information, even through this internet, however is lifted in case of 11 categories or classes information mentioned in section 8. This is apparent from the opening words. Notwithstanding anything contained in the act, there shall be no obligation given to the citizens. If the provisions are seen together, primarily the obligation to facilitate the public access, even through the internet, cast by section 4 do not apply in respect to the information and do not fall under section 8 of the act. Therefore, considering all the views and materials, the CPIO and concerned IPOs of the state, as the case may be, can pass appropriate orders, including directing the disclosure. This order is appealable when it is passed, as it has been held. Moving further, what the Honorable Court has seen, that the provisions of section 8J, which was also argued that while taking the shelter of right to privacy, by taking the arguments regarding the information as confidential information apart from the information kept under the fiduciary capacity. So it was ultimately held after a long discussion that in view of the discussion, it is held that the contents of assets declaration pursuant to the resolution 1997 and the 1999 CGI conference, the conference resolution, the information seeker is entitled to be treated is entitled for the relief, and it was said that the information may be accessed in accordance with the procedure as prescribed under section 8J, 81J. It was further said that there are not otherwise subject to disclosure as far as the information sought by the applicant in this case is concerned. Whether the declaration was made pursuant to the resolution 1997, the procedure under section 81J is inapplicable. Now, in totality, what comes out that these assets declaration before the office of the Supreme Court by the Supreme Court judges, it was treated as an information. And the question of the information seeker was only to the limited extent whether that declaration has been submitted by the Supreme Court judges with the office of the CJI or not. So, after considering all these facts, the Honorable High Court said that this is an information. Apparently, it cannot be said to be having in that office under the fiduciary capacity of the CJI. As only the information has been sought, whether it has been submitted or not, it can be provided, and it was directed to be provided. But further, the contents as which have not been asked by the applicant, the informant seeker, and even the reflection and the ratio of law as it is appearing in this case, it says that whatever the department of the office feels that it is this consent, the contents of some document are protected, then in those situations, the invocation of section 81J is to be dealt with. And when these informations are to be provided, the notice in the shape of third party is to be issued. And facts of each case are to be seen, under what circumstances the contents of a document can also be provided. So meaning thereby, the applicant Subhash Agarwal, on both his queries, was firstly allowed by at the first stage for providing the resolution, and the second query, which was only in relation to the declaration information, that was also directed to be provided. Now proceeding further, what more was evaluated in these and how those were answered, as I had elaborately detailed, but the Honorable Judge, while concluding his judgment, has also said in brief what were the issues which were framed and how they are answered. So the issue number 1 and 2, which was jointly decided, was that whether the CJI is a public authority and whether the CPIO of the Supreme Court is different from the office of the CJI. So the answer comes in narration is that the CJI is a public authority under the RTI Act, and the CJI holds the information pertaining to the assets declaration in the capacity as a Chief Justice of capacity of a Chief Justice. That office is a public authority under the RTI Act, and that office being a public authority is governed by the provisions of the RTI Act. The point number 3 in the shape of issue number 3, whether the asset declaration by Supreme Court judges pursuant to the resolution of 1997 are information or not, it was also answered, and that second part of the respondent's application relating to the declaration of the assets by Supreme Court judges is information. Within the meaning of the expression of section 2F of the Act, the point is answered accordingly. The information pertaining to declaration given to the Chief Justice of India and the contents of such declarations are informations and subject to the provisions of 81J, as it has been elaborately detailed, under what circumstances it can be provided, how it can be said to be confidential, and what is the interest, how the public, the information seeker can set that it is required to be in the larger interest of the public so that it is to be made a disclosure. So that aspect is to be investigated by the CPIO concerned before whom the application has been made. The point number 4, if such declarations are information, does CGI hold in a fiduciary capacity? And are they therefore exempt from the disclosure of the act? It was answered by the single judge. The petitioner's argument about the CGI holding assets declaration in a fiduciary capacity, which would be breached if it is directed to be disclosed in the manner sought by the applicant, is insubstantial. The CGI does not hold the declaration in the fiduciary capacity or relationship. So this argument was also negativated by the Honorable Single Judge of the Delhi High Court. Point number 5, whether any such information is exempt from discovery from the disclosure by reasons under section 18J, it was answered. It is held that the contents of assets declaration pursuant to 1997 resolution and 1999 judges conferences resolution are entitled to be treated as personal information and may be accessed in accordance with the procedure prescribed under section 18J as we have discussed. Point number 6, whether the lack of clarity about the details of assets declaration and about their details as well as the lack of security renders the assets declaration and their disclosure unworkable. So it has also been answered in the judgment. And what was finally, the appellate authority had recorded, as it has been observed, a perusal of the application of this applicant dated 10/11/2007 discloses the appellant had sought information relating to the declaration of assets by the Honorable Judges of Supreme Court as well as the Chief Justice of the states. In view of the finding recorded above, the first petitioner CPIO shall release the information sought by the respondent applicant about the declaration of the assets. So only to this limit it was directed, and only to this limit the order, which was this the CIC order, it was upheld, and the contentions of the petitioner CPIO were rejected, as it has been mentioned and as I have stated, not the contents of the declaration, as that was not sought for. So the question as raised by the applicant, the information seeker, he may not have framed it properly, but whatever he has asked, that has been provided to him. And what other in situations which has been discussed in depth by the Honorable High Court, that it is to be considered by invoking the provisions of section 81J if the contents are sought to be declared or sought to be provided to them as in the larger interest of the public. So this petition was decided with these directions. And after passing of this judgment on 2nd September 2009, again the petitioner of this writ had filed a latent patent appeal, LPA, before the division bench of the Honorable High Court of Delhi. And all these points were raised before the division bench of the Delhi High Court. And ultimately, after discussing all these issues in length, after discussing the all case law, after discussing the findings made by the London single judge, after evaluating the legal analytical approach regarding the reasonings given by the London single judge, the division bench concluded that there are no merits in the appeal, and the appeal was also dismissed by the division bench, as it was held that they are satisfied with the judgment as impugned in the appeal, and the learned single judge is both proper and valid and needs no interference at the end of the division bench. So meaning thereby in detail in this single matter. Almost the sections of the RTI Act, which in routine are being invoked by the citizens of India, by the people of India. These are the basic points, these are the basic sections which needs evaluation, and those all sections were fully dealt with in this judgment, wherein it was found that how and in which manner these sections are to be invoked, what is the appropriate legal applicability of these wordings of this section, what actually it has been envisaged in the section, do it available with the public or the officers concerned who are meant for providing this information, how they can act, what they can withhold, how the powers are to be dealt with, and in which manner these are to be exercised, so that there may not be harassment for the public, or they may not run from pillar to post for considering their aspects, their request, how their informations are being withheld, or in what manner they are entitled for the information. So this case law in itself completely and explicitly expressing clear that what are the information, what are the public authority, what about the fiduciary relationship, and what informations can be said to be protected and under what circumstances. So apparently these are my viewpoints in regard to this judgment. These are my submissions in relation to this judgment. And this small act, which have a unmeasured depth in the society, thereby providing the citizens to have information. So in order to conclude my submissions, I would like to say that no doubt, and there cannot be any dispute about the fact that RTI Act has brought a new revolution in the governance of the country, from the culture of secret to the openness and transparency. It makes empower citizenry, where administration are made accountable towards them. Though the RTI Act, it is only having a life of 15 years, but still has a long way to go to see its impact. But nonetheless, during this period, it has become one of the most popular enactment, and where the public of the country feels that they cannot at all be said to be cheated in by any of the authorities during the course of the governance. So one of the observation as made by the Chief Information Commissioner, Satyanand Mishra, he has rightly observed that the right to information, whether weighted the apathy of the people for more such rights, the right to employment, guarantee, education, public service delivery, food security, and corruption-free government are some of the rights we have been ourselves or are in the process of giving only because the ground was prepared by the Right to Information Act. It can justify claim to be mother of all rights. So there, by virtue of the enactment, by virtue of the provisions of this enactment, the citizen, the public of the country have every right to know what is being governed by them, whether the policies which have been circulated, whether the financial institution or whether the financial aspects which are required to be spent, which are meant for public, which are meant for the developing country, which are meant for developing a particular state, are those funds or those information or those offices are working properly within the duties as assigned to them, whether the discharge of public functionaries is good in law as it is meant for them to do for adhering the law in the society. So these are my submissions. Now I am over to the board of the law court.
Thank you so much, sir. It was quite enlightening and elaborative. Now, I would like to, now the session is open for question and answers. If any of the participant is up
Yes.
with a question, they can use the raise hand option available in the application, after which we can unmute you for the question to be asked from our sir.
Yes.
Hello.
Hello. Anji, yes, please.
Anji sir, good afternoon. My name is Rinda Gupta. I am from IIT Institute of Management and Technology.
Yes, please.
Sir, I want to ask that if we have filed a case against a person and we want to against a person,
okay.
If we have filed a case against a person and we want to have the knowledge about the property he is having and the knowledge like about who is the owner of that house and all the information about his property, can we file a RTI and what is the procedure for that?
Basically, the invocation of the provisions of RTI Act,
Yes, sir.
as it has been detailed, and the sections also provide that these informations can be provided by the public authorities. Suppose you want to seek, as your question is, that you want to know about the details of a property.
Yes, sir.
If that property is registered with the office of sub-registrar concerned of that area, so all the sale deeds are termed as public documents, and you can obtain the copy by making the requisite payment of that document. So there cannot be any hurdle, but you have to disclose that you want the details of X property, Y property, and a procedure is prescribed. So that authority, being a public authority under the RTI Act, is bound to provide you that information.
Okay, sir. Okay, thank you, sir.
Okay, welcome.
Is there anybody else who want to ask a question? They are mostly welcome. Yeah, kindly mute Udit Jain. He wants to ask a question.
Hello, sir. Am I audible?
Yes, you are audible, please.
Sir, my name is Rikhil Chopra. Sir, recently our Prime Minister made a fund called the Prime Minister Relief Fund for the COVID-19 and everything. Sir, if we want to know that the money which has been donated by people, celebrities, etc., that where all the money has been used, so can we file a RTI against that?
In that context, as I have discussed in the judgment also, while adhering the provisions of RTI Act, we have to see that under section 24 or other under provisions of this act, whether this information could be said to be protected or not. The office of the Prime Minister is to be seen whether it could be held as a public authority. So keeping these ratio, while having all these things in mind, it can be applied, it can be agitated before the concerned authority. If so appointed, first of all, we have to see whether the first authority that has been originated for the purpose of dealing such applications. So if it is exempted, then the law says as envisaged in the act. And if it is not exempted, then we have a right to have that information by way of the RTI application. There cannot be any hindrance to that effect.
All right, sir. Thank you.
Hello. Good afternoon, sir.
Good afternoon.
So I want to ask that we are talking about Prime Minister's office and CGI office to come under the ambit of RTI Act.
Yes.
If this happens, is it benefit the public at large, or it will be only a political? It
No,
will
it
only
cannot
for
be.
political benefit.
This whole thing is to be seen. Being a citizen of India, if we are acting bona fidely and we want to seek the information in right perspective, then it is going to be benefited. Everybody will know how the amount is being spent, what are the platforms on which this amount is being spent. If a person is acting malafidely by making an application, becoming an information seeker, then obviously his designs would be bad in the law, and those would be or might be being used for political purposes or for any other purposes which are not good for the public at large. So whatever information is sought, it is sought for that a particular act which has been assigned for a particular purpose, whose ultimate achievement would be for development of a society, and it is for the public at large. So keeping that ratio in mind, if information is sought, obviously it will be benefited to the society at large. And if a person is acting malafidely, then his motives can be designed or can be measured at the level when he will caught by misquoting that information anywhere in the society.
But sir, I want to ask that for funds and these money matters, comptroller and auditor general has a work to do on these objectives.
And what I want to say that suppose an X amount is assigned for a Y project, and a particular PWD department or a forest department or a medical department, they have been provided with that particular fund, because this fund is bound to be used for public, for the benefit of public. So you can have details, this X amount which was released to you to be spent for the benefit of public. You can seek details by way of maintaining these RTI applications, on what account, how much amount, on what score, for whom it has been spent. So these all information a citizen of India is legally entitled to have by invoking the provisions of RTI Act.
Okay, sir. Okay, thank you, sir.
Welcome.
Is there anyone else who is seeking for an answer? Yeah, then we have not got any more questions. I think that your speech, your lecture was more like very much clear, so that the participants don't need any more question to ask from you. So thank you so very much, sir, for coming, and we will like to have you in future to come. Thank you, sir.
Thank you. Thank you.
So we would like to rest this session over here. Thank you.